on air, I was searching and looking for someone who might have a different perspective than me on the memo that was produced by the House Intelligence Committee on their oversight duties concerning the FBI. And I read an opinion piece the other day in the Detroit Free Press by someone who had a different opinion than I and had a background that could address these issues, probably more informed from the law side, I would say, than I. And I found, and I emailed her, and she was gracious enough to come on air today. Her name is Barbara McQuade, as I've been telling you. She's a professor at the University of Michigan Law School, and she used to be a U.S. attorney for the Eastern District of Michigan. She was appointed that U.S. attorney position in January of 2010 by then President Barack Obama. So welcome to the show, Barbara. I appreciate you coming on air and taking up my invitation. And why don't you first give us a kind of an overview, I guess, on your general feelings about the piece, or what motivated you, I guess I should say, to write the opinion piece that was published in the Detroit Free Press. And by the way, just so people know, if you go to the web 95.3 WBCK.com, my flagship station or one of my affiliates, you'll see the promotion for this interview, and there's a link to her piece in the Detroit Free Press on that. So again, welcome to the show, Barbara.
Oh, thanks very much, Renk. You know, my purpose really is just to try to help provide information to the public about what FISA is, how it works, and maybe try to explain why it's so extraordinary that FISA material is being released to the public, and suggesting maybe there are other motives afoot here because it's so extraordinary to release this information. And once you read the memo, which to me was quite underwhelming, one wonders why we would risk the compromise to our intelligence community just for that. FISA is a statute that was enacted 40 years ago to protect the public from government abuses of wiretapping by the executive branch. You know, before there was FISA, the president could surveil people in the name of national security whenever he wanted to, and there were some abuses there of Martin Luther King and Vietnam protesters and the like. And so Congress created FISA, the Foreign Intelligence Surveillance Act, that created this court that approves and oversees foreign intelligence surveillance with some oversight to make sure that it's being done fairly, that there's probable cause. But in the 40-year history of FISA, those FISA applications have never been made public because they rely on intelligence information, some of which is gathered from other foreign intelligence services that trust us to take good care of that information and make sure it never sees the light of day. So the Justice Department said the release of this memo would be extraordinarily reckless, and so I was surprised that Congress would do so. I expected some huge bombshell to be in it, and instead it was simply an allegation that they had not precisely disclosed a potential bias of one of the sources. Not even that the information itself was wrong, just that maybe they failed to disclose in detail the bias. And now we're hearing from the Democratic side that they actually did disclose the bias. And so one wonders what could be at work here. Is there some perhaps political motive as opposed to simply blowing the whistle on abuses by the FISA court?
For years, the government wants everything classified. Everything has to be classified. There should be no transparency. I'm talking about these agencies with to the American people. They don't deserve to know what we're doing. So we have these oversight committees who are supposed to be doing their job because that's who the FBI reports to. They're not their own, unit of government in the sense of, we do, and what we do is always great and upfront and nothing will ever happen. Are you embarrassed that all these people, including the DOJ, the FBI, and all those people who went out, the Democrats in this case, because it was the Nunes memo, sat there and told less than the truth, let's put it that way, that there would be all this bombshell source and methods exposed when it was all a lie? There was not one. You yourself just admitted there was nothing in there. So why would they fight so hard to show nothing?
Well, I think it's the precedent that we don't disclose, for one, the fact that the name of the target of the surveillance, the fact that there was a FISA up on him, There was details that newspaper articles were used in support of it. All of those things are things that have been for 40 years kept carefully secret. And now there's, I think, terrible precedent that when there is some political agenda at play, we release these under the guise of whistleblowing, when in fact, the only whistle that was blown here was that maybe they failed to specifically describe which political party or which political campaign had funded the research. When it apparently.
But don't you think that's a material? Don't you think that's a material thing to know, that if you were a judge and you sat on a court and you weren't told by the prosecutor that all this information we have that we're presenting to you is actually by a political opponent of this person? It's Oppo research. You don't think that is good, that a judge would want to know that, and a judge wouldn't be angry that he was or she was maybe misled?
So, number one, it sounds like from the Democratic response, we'll find out if that memo gets declassified, that they actually did say that Fusion and Steele had a political, were politically motivated. So we'll have to find that out. But number two... Well,
not just Fusion and Steele. You skipped over something. You skipped over. It was the Democrat Party and Hillary Clinton who paid for it, not just Fusion and Steele.
So, yeah. So, well, we'll see what the memo says in terms of what was disclosed. But you're right. Ordinarily, it's best to include information of bias, but the legal standard was articulated in a case called Franks versus Delaware, and there the standard is that if you want to challenge a statement in an affidavit, you have to show that it was false, that the false statement was made knowingly or recklessly, and that if you are to if so, and you remove that, then the entire application is lacking in probable cause because there's not enough other evidence to support it. There's no allegation that the statements are false, that they were knowingly false, recklessly false, or that this was the sole basis of probable cause for the affidavit. So for those reasons alone, that's why I found this memo to be so completely unpersuasive, because even if this allegation is true, it doesn't rise to that legal standard.
Who would bring that up in this case of the FISA, that they knowingly gave false information? Whose responsibility would be in that process in FISA? Because there's no real defense attorney.
Well, the court has the ability to appoint amicus lawyers if it wants to argue the other side of the case. But I agree with you. In a case like this, it's difficult to identify a false statement. What happens is there's something known as the Woods procedures, where within the Justice Department, there is a lawyer and an agent who go line by line through each statement in that affidavit to make sure that it's true, and they attest that they have completed that process before they provide it to the court. Now, you're right. It's not tested by defense counsel. We have to rely on the executive branch to do that, but they're sworn to uphold the Constitution and to follow those procedures. And so that's the system that Congress has come up with in this very unusual world of foreign intelligence, where we want to have court oversight, but on the other hand, we need to keep confidences.
Do you have a concern, being a former U.S. District Attorney, that of the thousands of, we're being told, FISA warrants that were sought, only a couple were ever denied? Is that rate sound a little should we as American citizens say, wow? I mean, who bats 990% or whatever it is?
Well, I think the reason for that high success rate is because of the incredible hoops you have to go through to get a FISA warrant. You can't just get one because you feel like it. You have to be able to demonstrate that the target is an agent of a foreign power.
Online with me is Barbara McQuade, a professor at the University of Michigan Law School, and she was a U.S. attorney for the Eastern District of Michigan, appointed in January of 2010, and then she's moved on to the law school at U of M, and she wrote an opinion piece the other day about this memo that the House Select Committee put out. They call it the Republican memo. The Democrat memo is supposed to possibly come out soon, and we'll see if any sources and methods. I'm hearing that sources and methods are being revealed in it, possibly, but we will see. I wanted to get her opinion because it was different than mine, and I wanted you to hear a different opinion on this issue. As I've said to you earlier, to me, this is not a partisan political issue. It's not a Republican issue. It's not a Democrat issue. There may be. It's politics. I guarantee there's politics involved by both parties. in Washington, D.C. Definitely. No questions asked. But to us, knowing what we know now in this memo and other things that we've heard, a lot of people think of it as something's not right here. It doesn't seem kosher. So, Barb, thanks a lot for coming on. At the end there, we had to go because of a quick, I had to exit quick because of my hard break for my affiliates to come in. I was asking you, should Americans, what should we think about this 99% success rate on FISA judges just signing off on these, and some call it rubber stamping these, and you started to answer that. Why don't you finish that for us?
Yeah, I think I'd be surprised if it weren't a high rate in light of the very high level of scrutiny that these FISA applications get through the Department of Justice. It starts with a field agent working with a lawyer. It goes through several levels of review at both the FBI and then at the Department of Justice. It has to be signed by either the Attorney General or the Deputy Attorney General. And so after all of those levels of review, one would hope that the application is very sound. And so, in fact, it would be surprising or even alarming if the success rate was lower. These judges are real judges. They are district court judges from all around the country who sit and hear trials in their day job. And then once a week, or for 1 week a year, they go and sit on a rotation. They go sit in Washington for a week, and they hear the applications that come before them. They're selected by the Chief Justice, Justice John Roberts, to a 7-year term to serve as a member of the FISA court. So these aren't, special intelligence or secret judges. These are regular judges who are in open court every day, except for the week that they serve on the FISA court.
Well, that's good to know. In your piece, you wrote, those who have seen the underlying classified documents say the memo was inaccurate and misleading. The FBI said it contained material omissions. Then why doesn't the FBI come out and show us where those material omissions were without exposing sources or methods? And then again, sources and method, we're not talking about a Russian spy or a Chinese spy. We're actually talking about sources and methods within the United States.
Well, I think they can't, and that's why it was so extraordinarily reckless to release this thing. They're sort of holding them hostage. They know the FBI can't respond because it's a crime to disclose classified information. The committee was only able to do it because of a rule of the House Oversight Committee, and that the president ordered it declassified. So their hands are really tied. They can't respond, and they know they can't respond. That's what makes it so difficult. And you say sources or methods. It's been designated classified. That means the release of it would, by definition, cause grave harm to the national security of the United States. So we don't know what it says. It could include Russian spies. It could result in someone's death. It might just be something as simple as some collection technique that they use. But whatever it is, because it's been designated classified, they can't say, that's harmless enough. They can't respond to it. And I think, to some extent, that's what the Republicans in the Nunes memo were counting on, that, watch this, we can make all these crazy allegations and no one can respond.
All right, Barb, then that really, what you just said really, really worries me as an American citizen. Because you're saying that this nothing burger that was let out in this memo, which the FBI and the DOJ and everybody on the left said that it's going to be explosive and it should be classified. There was nothing in there that I, as a citizen, would look at and say should be classified. Are you kidding me? They are classifying way too much stuff. What are your thoughts about that?
Well, there is an argument that many things are overclassified. So that is a general matter. I think there is some merit to that. But we haven't seen the whole document. We've seen three and a half pages discussing the document. We don't know what else is in it. And so the precedent of releasing that and then holding the FBI hostage to be able to respond to it is what is so irresponsible, because we don't know what else is in it. We don't know who else gets identified, what sources get identified, what methods of collection get identified. And so the nothing burgerness of it is its significance in terms of the allegation is a failure to disclose a particular bias.
So what do we do? I only have
a lot of substance to the affidavit itself, because it convinced the judge there was probable cause 4 times.
So I think we need but that's your assumption that we're dealing with honorable people here, not the judge. These people who submitted it, and we're finding out more and more that we weren't dealing with we were dealing with very biased, non-honorable people, and nothing in the dossier has been proven or pretty much nothing has been proven. Yet, I know what you meant about, and you pointed out about the 4 different times in your piece that it had been, or 3 different times, I think, whatever, it had been actually released, updated. I'm trying to look for something here as I'm talking about.
It was
renewed, yes.
3 times.
But to that point, all it takes is some material fact to be proven, and it can be renewed. It could be the minor or some material fact, what we're hearing from these experts, quote-unquote experts, out there. In the few minutes we have left, then, this memo, I assume, is going to come out from that Adam Schiff wrote, this 10-page memo that he wrote right before the Republican memo came out. And it's going through its process. We'll see soon. I hope it is released. And I hope he isn't put in any sources and methods in there. The word is that he has as a bomb so it doesn't get released. And then he can play his political games. They all play political games. We can agree to that. But now what? Should we not have this FISA application released so we can feel comfortable as an American people on what actually may be happening in this case alone? Make this a special case.
Well, I know that Deputy Attorney General Rod Rosenstein was at the White House yesterday giving his opinion on what he thought should happen. I don't know what that opinion is. My guess is he's going to make the same advice with this one that he did with the last one, which is to not release it because of the way that it could compromise intelligence information and the very bad precedent it sets for the future to disclose these FISA applications, which the Justice Department has worked so hard to keep closed for 40 years. And so I think they're going to argue that it not come out. We'll see. It seems in the interest now that we've got the other one out, as a political matter, it would be very difficult not to disclose the Democratic version of it. But
right, we both agree on that. We both agree on that. I only have a few seconds left with you. But I'm saying now, should we see the actual FISA application with its redactions to see exactly? Judge Napolitano, that you may know, said, let's see it. And we'll see who's lying. We'll see who's spinning, left, right, or both of them.
That's so dangerous. I can understand. And the New York Times has filed a motion to disclose it. They said now that so much of it has been revealed, there's great public interest that outweighs its secrecy. But, boy, as someone who worked on these cases for years, I would hate to see us go down that road because I think it just opens the floodgates anytime there's some allegation in relation to one of these FISA applications that we're going to just blow up the whole system.
All right, Barb. Thank you. Sorry, but I got to go hit a break here. Appreciate very much you coming on air. Very much. Thank you.